Hi, everyone. I'm Cliff Kirsch, and I'd like to welcome you to the Eversheds Sutherland Webcast Advisors Act Regulatory Series fourth quarter update. And I'm joined today by my colleagues Michael Koffler, Issa Hanna, Bria Adams, and Ben Marzouk. And this webcast is our latest in our series of webcasts dedicated to issues impacting advisors. Just a quick couple of housekeeping notes before we begin. For those of you who would like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. If you have any questions during the webcast, please submit them via the Ask a Question text box on your viewing console. And also, anybody who wants a copy of the slide deck, just feel free to reach out to any one of us and we'll get you a copy. So we have a good amount to cover today on the webcast. We're going to first look at OC's risk alert on the cash solicitation rule. From there, we're going to sort of give a couple of thoughts on the things that you may want to be thinking about as you think about your firm's 2019 ADV update. We want to give an update on the fiduciary initiatives at both the federal and the state level, talk about GIPS 2020, mention in particular one enforcement case, and then chat a little bit about the year ahead, the 2019 regulatory agenda. So with that, we'll go to the first item, OC's risk alert on the cash solicitation rule. And Bria, can I hand that over to you to go through?
Thank you, Chris. So OC issued a risk alert in October 2018, which outlined compliance issues related to the cash solicitation rule, specifically in the case of third-party solicitors. As you may recall, the cash solicitation rule prohibits the payment of a cash fee, directly or indirectly, to any person who solicits clients for the advisor, unless the advisor and solicitor comply with the conditions of the rule. The rule defines the terms solicitor and client and provides requirements applicable to any solicitation agreement, and those are listed here. So on the next slide, the rule also provides requirements applicable to specific categories of solicitors. So solicitors may fall into three categories. The first category being solicitors who provide impersonal advisory services only. The second category includes solicitors who are affiliated with the advisor for whom they solicit, for example, a partner, officer, director, or employee of the advisor, or a partner, officer, director, or employee of a person which is controlled by or is under common control with the advisor. And then the third category includes solicitors who are third parties who do not fall into either the first or second category. So on the next slide, we give you a refresher of third-party solicitation. It requires a written solicitation agreement with the information outlined here. In addition, the advisor must make a bona fide effort to ascertain whether the solicitor has complied with the agreement, and the advisor must have a reasonable basis for believing that the solicitor has complied with the agreement as well. Finally, the solicitor must provide the client with a separate written disclosure document that contains the information listed here. On the next slide, I just want to do some key takeaways based on the risk alert, which the SEC noted from common deficiencies in examinations. First, advisors must obtain acknowledgement that the client received solicitor disclosure documents. In addition, advisors must make sure that solicitor disclosure documents include the nature of the advisor and solicitor's relationship, the terms of the compensation arrangement, the actual compensation terms agreed to, avoiding vague or hypothetical terms, and the additional cost the client is charged in addition to the advisory fee. Advisors must also make sure that they receive from the client, either before or at the time of entering the advisory agreement, signed and dated client acknowledgments for advisor brochures and solicitor disclosure documents. A few additional key takeaways on the next slide. Advisors must also make sure that written solicitation agreements include an undertaking by the solicitor to perform its duties under the solicitation agreement in a manner that is consistent with the advisor's instructions, a description of the solicitor's activities and the compensation to be paid, and requirements for solicitors to provide clients with the advisor's brochure and solicitor disclosure document. Finally, advisors must be able to describe the bona fide efforts taken to ascertain whether third-party solicitors complied with solicitation agreements. Is there anything that either Michael, Cliff, or Issa would like to add there? If not, then I'll turn it over to Issa on preparing for 2019 Form ADV update.
Yeah, just chatting a little bit about it. And thanks, Bria, for that recap. So I would say there was not a great deal new, in terms of the risk alert. I think what OC was trying to do, and we've seen this a couple of times this past year, and we'll probably see it a few times in 2019. I think they're just trying to, we're seeing more and more come out of the SEC's OC office, and it could be, simple reminders like this. But in terms of just this whole discussion, and Issa, I'm going to ask you to weigh in on this. One question came in from from someone who's listening, basically saying, what are we hearing from a regulatory oversight provision? And the question specifically is, we've heard that some states are requiring registration of a solicitor. And I think the question is coming in from someone who's an SEC registered advisor and maybe takes advantage of third-party solicitors. And sort of the question comes in, what are we hearing from the states about whether they have to be registered or not?
Great. Yeah, I'd be happy to take that question, Cliff. And the person who asked that question is definitely right. There are a number of states that have taken an interest in this question of whether a third-party solicitor for an SEC-registered investment advisor is properly licensed under the state securities laws. And typically what they're asking is, hey, are your third-party solicitors, is this third-party solicitor properly licensed as an investment advisor representative in the case of an individual, and if a firm is receiving a fee, is that firm separately registered as a state-registered investment advisor under our state's laws? And it's, that question has taken a number of investment advisors by surprise. A lot of folks are not familiar with the obligation, to license solicitors in that investment advisor representative capacity. And it's definitely a live issue. There are definitely a number of states that are asking that question. So it is something to, be aware of. I think the way for, an SEC registered investment advisor to deal with the concern is to be very clear and upfront with your third-party solicitors that they may have a state licensing obligation. Ask them upfront whether they have diligenced that issue, whether they have complied with any applicable law. You may want to go ahead and do some research or some outreach on your own to see what state licensing requirements might apply in the states in which you're engaging third-party solicitors. Just to make sure that you don't have any potential liability there. And then finally, another thing that you can do is you can include explicit language in your agreements with these solicitors, putting the onus on them to make sure that they're compliant with the state securities laws around licensing for solicitors. So those are some practical suggestions that you can take away from this, but takeaway here, it's definitely a live issue. It's definitely something that states are paying attention to, and it's possible that you as an investment advisor could get an inquiry about this from a state securities regulator.
And one thing that states are also looking at is a solicitor really acting as an advisor?
That's right.
What is the limits of, and you think, what is a solicitor? Someone who makes an introduction, makes a handoff, but not providing advisory services.
Right.
And just adding on that, I mean, a bunch of states have, as part of, it's built into their statutory definitions of investment advisor, includes solicitation activities.
That's right.
So a number of states, it doesn't even matter whether they're providing advice because their statutory provision explicitly captures those who are merely making those referrals.
That's right. Yeah, and that's a key distinction between the Investment Advisors Act and a lot of the state securities laws.
Right.
The Investment Advisors Act and the definition of an investment advisor representative under the implementing rules don't include solicitation activity within advisory services explicitly, but you'll see that in a lot of the state securities laws that solicitation is explicitly included within that definition of investment advisory or investment advisory representative activity. So that's something that you can look at as part of your diligence.
Great. So why don't we pivot now to some things to think about as you start to prepare your Form ADV updates for 2019, and we wanted here to introduce just some topics based on current developments that you may want to give thought to as you update. I'm going to turn it over to Issa for that.
Great, thanks, Cliff. So yeah, the goal here in this part of the discussion is to provide some practical, actionable items in which you could potentially make some updates to your Form ADV brochure. Form ADV update season is coming up. We know that a lot of today's listeners work for investment advisors that have a fiscal year end of December 31. So we thought, what better time to talk about potential updates for the Form ADV brochure, given that a lot of folks here going into the new year are going to be starting to think about that, given the deadline of the end of March for the annual update. So we didn't want to provide a discussion of kind of soft conflict of interest type topics to talk about. We wanted to kind of provide some actionable items, take a look at what's happened over the last year or so, what the SEC staff has been saying about investment advisor compliance issues, and what we can take away from that from a Form ADV disclosure requirement. So moving on to the next slide here, just getting into the first topic. First topic here we thought would be something ripe for disclosure, has to do with the inadvertent custody question. And a number of you are probably already familiar with this saga relating to inadvertent custody, but there's been a good amount of guidance back and forth between the industry and the SEC about this inadvertent custody question. And just to kind of sum up the issue, there are a number of custodial agreements out there between with big custodial firms that that contain language, stock language, allowing an investment advisor some access to a client's funds or securities. And it's it's standard language. A lot of custodians just included in there as a matter of course, didn't necessarily think about the implications under the custody rule. But the issue kind of took a lot of investment advisors by surprise, and the SEC, with respect to its guidance in the custody rule, has over the years come to the conclusion that even though an investment advisor doesn't have any control over that agreement, it's an agreement entered into between a client and a custodian that does give rise to inadvertent custody, because the language says what it says. It allows an investment advisor to access the funds. So as I said, there's been a lot of back and forth between the industry and the SEC staff about this, and the SEC staff has been trying to come up with a solution, what to do about this inadvertent custody question. And one, the latest, chapter in this saga is a piece of guidance that came out over the summer in the form of an FAQ, where the SEC staff said, okay, in this particular circumstance, we'll deem you not to have custody over the implicated client assets. And you can read the FAQ guidance here. And in terms of disclosure for consideration here, what an actionable kind of step you can take here to respond to this. One idea that we had was to get yourself the benefit of this guidance, to make sure that you get the client consent to your practice around inadvertent custody. You can develop some language for your Form ADV brochure that basically gets your clients to consent to the notion that you're not putting them with a particular custodian, you're not recommending one, you're not requesting, you're not requiring them to go with a particular custodian, and you have no idea what their agreement with that custodian says about custody issues. And that's, we think, one way in which you can make an argument to SEC staff that, notwithstanding what that agreement says, you got your clients to agree that you didn't have custody over their assets. Michael wanted to make a quick point on that too.
Yeah, just so folks are aware, there's still a fair amount of back and forth between the Investment Advisor Association and the staff about this FAQ, because it is not as helpful as people would like. If you look at the last couple of lines of the first sub-bullet on the page, the relief is not available where the advisor recommended, requested, or required a client's custodian. And I can sort of understand the staff's point of view with respect to required, but merely recommending a third-party advisor, if you look at the definition of custody, it's really about, do you have the funds or access to client funds or securities, directly or indirectly? Where does this? So, why is the status of custody hinging on whether you recommended a custodian? Like, where's that in the rule? Where's that in the rulemaking history? Where's that in anything that's related to the policy underlying the definition in the rule? So, and look, it's not unusual for clients to say, well, go to the advisor and ask them, well, who do you think I should go with? Should I go with this one? Should I go with that one? It's not unusual for advisors to answer that question. Merely making a recommendation to an advisor, to a client regarding the custodian now determines in certain fact patterns whether you have custody, which is just something that doesn't really sit well with me and many other people because it has nothing to do with the definition of custody. So just so you know that the IAA is still having these conversations, is still trying to get better relief than what the staff has provided up till now.
All right, thanks, Michael. Moving to the next discussion point here, something that you can kind of, take into account, regulatory development you can take into account as you're updating your Form ADV in the upcoming cycle for updates, is relates to senior investors. There's been a lot of activity on the senior investor front, protecting senior investors from financial exploitation. And I've laid out a few prongs here in which the regulators, Congress, have been trying to address this issue of the protection of senior investors from financial exploitation. The first is the Senior Safe Act, which was a congressional initiative providing limited immunity to investment advisors and other financial services firms when they disclose a suspected exploitation to a regulator or a covered agency. The second is FINRA Rule 2165. Obviously, that's a FINRA rule. It's not directly applicable to investment advisors, but as I'm about to get into, there is some fallout there for investment advisors. And the third has to do with the NASA Model Act that aims to actually require investment advisors and broker dealers to make reports of financial exploitation to certain regulators and adult protective services agencies. It's a fair question whether there's an applicability here to SEC-registered investment advisors. It really will turn on whether the Model Act in a particular state is adopted under a state's anti-fraud authority and ability to regulate an investment advisor's fraudulent activities. If it is, then I think there's a good argument that it does apply to an SEC-registered investment advisor. So that's something to keep track of as you're tracking the applicability of these laws to your SEC-registered investment advisor. In terms of disclosure for consideration here, the first point you can make has to do basically with privacy. There's potentially a privacy concern here if you're sharing your client information with regulators, and they may not know about it, they may not agree with it, they may not like it. So one thing that you can do to deal with potential client relationship, client management issues associated with privacy is to give them a heads up. Hey, we're going to let you know here that certain law requires us to make these disclosures of your non-public personal information if we suspect that you're somebody who's subject to financial exploitation. So that's the first thing that you can do. Second thing you can do, and this relates back to the FINRA rule that I was mentioning earlier, FINRA Rule 2165, is to let your clients know, hey, we're using a broker-dealer either to introduce your trades to a clearing firm or another broker-dealer that's a custodian that's subject to FINRA Rule 2165. Those broker-dealers are subject to FINRA Rule 2165, and they have the ability to place a temporary hold on your account, and we as the investment advisor have no ability to release that hold, to override a decision to put a hold on in the first place. So just to make you aware, that could happen to your account, and we can't really do anything about it. So these are a couple of things you can do to react to these developments. Michael, you want to make a quick point?
Yeah, just going back to the bottom of the prior slide, Issa, about the NASA Model Act. Companies are kind of in a difficult position because some of the legislation is really poorly drafted as to how and whether it applies to SEC registered advisors. Recount that under NISMIA, passed by Congress in 1996, SEC registered advisors are not subject to state law regarding state registered advisors, except if those laws are adopted pursuant to the anti-fraud authority of the state. But I'll give you an example. One state, their implementation of this Model Act states that it applies to advisors, which under the state code is defined as only being state registered advisors, and individuals who are registered as IRs. Now, you can have individuals registered as IRs with the state who are supervised persons of an SEC registered advisor. So you would end up with this really bizarre situation where just looking, if you leaf through the language of this particular state, and I think it's somewhat representative of other states, you end up with the conclusion that the individuals who are supervised persons of an SEC registered advisor and registered with the state as IRs are subject to this obligation, but the entity is not, which is it's such a bizarre conclusion. That's clearly not what was intended by the state, but that's what their language says. And you have similar kind of issues raised in other states as well. So it's very, because of the poor drafting and a lack of legislative history, because the states were not really giving this enough attention when they were rushing to adopt these provisions, you have these tricky questions arise as to exactly how these provisions apply to an SEC registered advisor.
You know, the one thing we're seeing, so there is a checker, the way the framework is developing as it applies to advisors. But that being said, the other thing we're seeing is SEC examiners just asking how, what sort of processes do you have in place? How are you thinking about senior clients?
Yep.
And I think sort of the overriding theme of sort of our discussion here, though, at least, is just you'll think about that in terms of your 2019 update.
That's a great point, Cliff, because, in speaking to clients about this issue for the last couple of years, it's been our recommendation that folks include this in their compliance manuals, because I think it's only a matter of time before the SEC says, under Rule 20647, the compliance rule, that you need to have this addressed. I mean,
right.
There's really no good reason why an SEC registered advisor would not have this issue addressed.
Right.
And it's just too easy for the staff to say it's a violation of 20647 if you don't address it.
Right. I think we're going to move forward, right, in terms of some topics or things to be thinking about given this past year's regulatory or enforcement. As you put together your 2019 update, I think, Issa, the next one is advisory fees and expenses.
Yep, exactly. So I'm going to try to run through these pretty quickly because I know we're kind of exceeding the allotted time that we had for this topic already. So, the next topic here had to do with advisory fees and expenses. There's been a significant amount of regulatory scrutiny in this area over the last year. You might recall that there was an OC risk alert that came out in April of this year. There have also been a number of enforcement actions that have been taken against investment advisors in the last year relating to fee billing, expenses, et cetera. And you might actually, one thing that's not listed here is actually a New York State action that was taken against, an investment advisor, significant action. I didn't note it here, but that's also something to take into consideration. The states are actually getting involved in this issue too. So. Just moving on to the next slide here, what to do about the expense and advisory fee issue. The main thing is to really just take a look at your disclosures to make sure they align with your current practices. And I think, the bullets here are pretty self-explanatory. I won't go through each one of them, but you should really sit down with your folks in your operations department to make sure that what you're laying out in your disclosures reflect reality. And that the way that people are being charged, and that the discounts that they're receiving, the householding that they're being entitled to, are actually being effectuated. That it's actually happening. So I think that's kind of the key lesson from the regulatory activity that's taken place over the last year relating to fees and expenses. Moving on to the next slide here, there was another OC risk alert that came out earlier this year. I think this is becoming a common theme. OC is getting heavily involved in the regulation of investment advisors, de facto regulation. So there was an OC risk alert that came out in July of this year, where OC noted a number of compliance issues that they've noticed relating to best execution by investment advisors. And within that OC risk alert, they laid out a number of topics that investment advisors could consider as they're putting together their disclosure around best execution in soft dollars. So I'm not going to run through each one of these, but they're pretty self-explanatory. But one thing that I really wanted to highlight was this last bullet point: has adequate and accurate disclosure been provided regarding products and services acquired with soft dollars that don't qualify as eligible brokerage and research services under Section 28E Safe Harbor? That's a really tough one. We've had a number of clients that have really grappled with that issue. Does it count? Does a particular benefit that's made available to you by a broker dealer really count as soft dollars? And if so, can we get it within that eligible brokerage or research services safe harbor? If not, then you have to be very, very careful about how you go about disclosing the issue, because if you're not, and the SEC catches on, I think it becomes a significant concern for you.
And just remember that the SEC's definition of soft dollars is extremely broad, and it includes anything other than execution, anything that might be viewed as having any value whatsoever, even if you don't think it has value in terms of you're not using it to help your business. If it has any value objectively, the SEC will say that's a soft dollar benefit.
Yep. Thanks, Michael. So just finishing up here, the last slide. This actually comes back to the risk alert that Bria discussed earlier, the risk alert relating to the cash solicitation rule. There was one interesting passage in that risk alert where OC said, hey, by the way, this doesn't really directly relate to the cash solicitation rule, but by analogy, if you have arrangements in place with service providers where they send you clients in exchange for continuing your business with them or engaging them, that's a conflict of interest that needs to be disclosed in your Form ADV. And to the extent that you're not disclosing that needs to go in. So that's kind of a silent assassin kind of point that the SEC made in that cash solicitor rule. Michael, you wanted to?
Yeah, just related to that, we are seeing a lot, particularly in 2018, we're seeing a real big expansion of the benefits, economic benefits made available to investment advisors if they send certain assets to third parties, whether it's a custodian. Custodians are being a lot more aggressive than they have in the past in terms of providing economic benefits, and also third-party advisories. So the so-called TAMPs. If you send money to one third-party management, one TAMP versus another, certain of the TAMPs are being a lot more aggressive in the financial benefits they are awarding to retail advisors, and we have not seen the level of disclosure be sufficient in many cases. It's not matching the incentives that are now being provided. And we see that as a big risk area in the future.
Yep.
Great. All right. So I think we're ready to move on. So I'm going to turn it over to Ben in a minute or so to go over the fiduciary developments. What we've been trying to do on these calls is just get you up to date over what's happened since our last webcast at the SEC end of things in some states. But Ben, before I turn it over to you, just for those of you who who want to receive CLE credit for today's webcast, I want to give the confirmation code. So it's TRENDS, TRENDS. So again, for those of you who'd like to receive CLE credit for today's webcast, our confirmation code is TRENDS, and please use this code for the sign-in sheet available for download from your viewing console. Thanks. And Ben, could you walk us through the fiduciary duty developments?
Yeah. Thanks, Cliff. So what I plan to do is discuss updates on the fiduciary initiatives at both the federal and state levels. Really, since we last spoke about this issue during our last webinar. So on the SEC side of things, as of course people know, they proposed in April of 2018 a standard of conduct rule that applies to both broker-dealers and investment advisors. There's sort of four components to it. There's regulation best interest, Form CRS, a titling restriction, and then restatement of the advisor fiduciary duty. For best interest, just at a high level, we've already covered it, but it applies to recommended securities transactions to retail customers and would impose that best interest standard just upon broker-dealers. For Form CRS, this is a customer relationship summary document, a brief 4-page briefer on the general elements and that distinguish a broker-dealer relationship to an investment advisor, and it kind of summarizes that relationship to the investor at the outset of the relationship, where that document would be provided and include all the necessary disclosures. The third component, the titling one, that generally restricts broker-dealers from using the term advisor or advisor in their names. That's both with an E and an O, so they could no longer refer to themselves, for instance, as a financial advisor. And then finally, there's just a restatement of the investment advisor fiduciary duty. So that was all proposed back in April, and there has already expired a comment period, a 90-day comment period that expired in August. They received, as we imagined, thousands of comments from a number of different industry groups, and we covered those on prior webcasts. In terms of planning as to when this rule might be adopted, the SEC releases a semi-annual regulatory agenda, both in the spring and the fall. And the most recent one in the fall that was released by the SEC had this on their rulemaking agenda as anticipated final action on the proposed rule in September of 2019. They're not bound by that in any way, but it's at least gives you some idea of when the SEC expects to take action on this. Moving on, the three general updates that we want to cover since we last spoke about the SEC's rule. The first being the SEC's Investor Advisory Committee, the second being the RAND report, and then the third being some general personnel changes and shifts of opinions with this rule. So the Investor Advisory Committee, and by the way, if people aren't familiar, I mean, this is just kind of a volunteer committee formed and sanctioned by the SEC that really includes everyone from former SEC commissioners to law school professors in the securities industry to finance professionals that have worked their entire life in this industry. So it's a collection of these voices that come together periodically to issue different reports or recommendations that generally are viewed as sort of to guide the SEC's rulemaking agenda. So what they did recently in response to this proposal, and this recently as in November 7th of this year, they issued a recommendation that was generally meant to, as they put it, strengthen and clarify the actual rule proposal. It was not unanimous. There were a few dissenting votes on the recommendations that the committee issued. But, generally what the recommendation offered is that they were, in support of the idea behind the rule, but they wanted to, clarify some of the more ambiguous terms in the rule, particularly when it related to what exactly a best interest standard meant. As people probably know, the SEC didn't really define what a best interest standard is in their proposed rulemaking. All they essentially said is that it was it would be not acting in the best interest to put your own interests as the financial professional above the investor. That doesn't really mean much. They did offer a limited safe harbor, and in order to satisfy that safe harbor, you had to meet three different conditions: a disclosure, care, and conflict of interest condition. And assuming you met each one of those three conditions, and there's specific criteria for how you were to go about to meet them, and some of them were kind of ambiguous, like mitigating conflicts or eliminating conflicts, and then deciding which conflicts could be mitigated only and which conflicts could not be mitigated and needed to be eliminated. Assuming you met each one of those conditions, however, you would then be deemed by the SEC to have satisfied the best interest standard. So, the committee felt that that definition of a best interest standard could have used a little bit more, clarity, and they actually, went as far to say that they felt that the best interest standard should actually be characterized as a fiduciary obligation, with the understanding that the fiduciary duty would be different depending on who the actor was. So an investment advisor's fiduciary duty for an ongoing monitoring of the investment would be fundamentally different from a broker-dealer acting in a one-time salesperson capacity. So that was a pretty strong recommendation, I think, from the committee. Generally, they, supported the idea, but wanted to actually enhance the best interest standard beyond where it currently was. Moving on, this sort of relates to the final bullet, where the committee also did advocate for further testing of Form CRS, that second component of the rulemaking. But on the exact same day that the committee came out with their recommendation, the RAND research report was issued, and this was a research report designed to study in specific the Form CRS and whether it really helped investors to better understand the distinction between a broker-dealer and an investment advisor. As people may be familiar with RAND, they had previously looked at this issue in 2008 after the D.C. Circuit Court of Appeals vacated the SEC's, at that time, the SEC's proposed rule that would have exempted fee-based broker-dealers from investment advisor registration. So they're familiar with the general issues that surround this, murky distinction between a broker-dealer and investment advisor, and had issued a prior report studying this issue. This is kind of an updated version of that report with the background of, the new SEC standard of conduct rule being the focus. And it was issued the same day, probably in conjunction with the committee's recommendation being released. There's as you can see here, I mean, this was essentially the report was conducted based on an online survey of, more than 1,800 investors, and then they also did in-person interviews with individuals. So the findings for the RAND report were generally positive assessments of Form CRS. They found that investors found the rule proposal the Form CRS helpful in understanding that distinction between a broker-dealer and investment advisor, and especially when it comes to identifying the key terms and the conflicts. There's beyond the bullets here, there's just a couple things I'd note here. One, it's an SEC commission survey, right? So, I think one could probably look at this and say that, the SEC, wanted, to some degree a positive outlook here and a positive forecast for Form CRS. So there's maybe a little bit of, inherent bias in the actual study. Secondly, these aren't extremely strong endorsements for Form CRS. I mean, saying something is helpful, which is the majority of, how far I think most of the survey respondents went in characterizing how Form CRS helped them understand the distinction between brokers and investment advisors. Saying something is helpful is not, an extremely ringing endorsement. So that's something to note. And then also I'd point out that there were some negative feelings. It wasn't entirely overwhelmingly positive. There were the majority of survey respondents, for instance, felt Form CRS was too long. Interviews revealed confusion between that distinction of a broker-dealer and investment advisor, especially when it relates to the fees and costs section of the Form CRS disclosure, which is a very important section for distinguishing between a broker's fees and an advisory fees. So that's some things to keep in mind as you consider the impact of how the RAND research report might ultimately weigh on the SEC's eventual approval of Form CRS. And then I guess moving on, the final update I'd note has to do with the personnel on the SEC. There's 5 commissioners. As people probably remember, it was a 4-to-1 vote when the rule was proposed, and 2 of the supporting votes at the time expressed, and that was Commissioner Jackson and Commissioner Peirce, expressed reservations about the proposal, saying that they, to some extent would not adopt the rule if it was being adopted that day. They were only voting for it just to propose it and seek comment on it. So with that kind of in mind, one of the commissioners that was a firm yes on releasing the proposed rule, Michael Pilar, left the commission, was replaced by Elad Roisman, who was just sworn in September of this last year. He was a Republican appointee, and during his confirmation hearings really didn't give too much indication, hasn't made any overt public statements about this rule, but during his confirmation hearing did note that the rule should be business model neutral, which would at least appear to suggest, a mild opposition to the rule proposal, to the extent that it might disfavor the brokerage model over the investment advisory model. He would prefer that it be business model neutral and that not favor one business model over the other. So it'll be interesting to see how his vote turns out, given that he was replacing a firm yes vote in POR on the committee. And then secondly, with SEC Commissioner Hester Peirce, who, like I said just a few seconds ago, expressed some reservations about the proposal during the SEC's open meeting on this back in April. Recently, in October of this past year, she has given some speeches expressing some strong support for regulation best interests and Form CRS, which is a bit of a switch from her prior statement. So she seemed to be moving from her initial reservation to maybe a solid yes vote on this proposal. But I'll pause there before jumping to the state developments and see if Cliff or Michael, you have anything to add on the SEC front.
Yeah, no, I don't think so, Ben. You go to the state stuff. Obviously, a lot more to come. The one thing I would say is the SEC staff and commissioners continue to meet with industry participants, investor groups. So it's a very active process. They're reviewing comment letters, but still meeting at the same time. So a lot going on, but a lot more to come. But given time, why don't we go to the state developments?
Sure. Yeah, and the main state we wanted to highlight here was New Jersey. I mean, keep in mind there are a number of states, about 6 or 7, that have proposed and in some cases adopted, like Nevada, for instance, have adopted explicit fiduciary duty standards that would apply to both broker-dealers and investment advisors. After Department of Labor's fiduciary rule was vacated, a number of states jumped to this opportunity, seeing it as a chance for them to regulate in this area, given that the Department of Labor's rule had been overturned, and given the fact that they weren't certain whether the SEC would propose or adopt a rule in this area at all, governing the standard of conduct for these actors. So New Jersey was the most recent state to propose rulemaking here. Just in October of 2018, they released a pre-proposal notice. So this is not actually a proposal yet. It's just a notice seeking comments on a proposal that would eventually require broker-dealers and investment advisors to be subject to a fiduciary duty. That's important because given the 6 or 7 states that we've been tracking that are regulating in this area, there's a handful of them that are proposing an explicit fiduciary duty, and New Jersey would be one of them. There's other states that are just disclosure-based only, where for instance, New York would require a broker-dealer to disclose that they are not a fiduciary to the client before making the sale. So there's some that are disclosure-based, but one like New Jersey is an explicit fiduciary requirement. And after their pre-proposal notice, they had 2 conferences, in-person conferences in November, to essentially gather facts and inform the rulemaking. Nothing was, released or published after these conferences, but the actual comments would be due, the written comments, in December 14th, and then after that, it would be up to New Jersey to decide, how they want to proceed and move forward with an actual proposal. A couple things to keep in mind. One, having to do with preemption. Michael mentioned this earlier. The National Securities Market Improvement Act of 1996 does carve out certain areas of federal law that the states may not regulate with respect to broker-dealers. So there's kind of, there's nothing explicitly that covers standard of care, but there are some general areas such as financial responsibility laws that have, more ambiguous meanings and could arguably rope in the standard of conduct rules and therefore preempt state regulation of this in the event that the SEC does actually adopt a separate standard of conduct governing this. And then finally, other states and the NAIC, the National Association of Insurance Commissioners, continue to be active in this. They have proposed a model regulation, a best interest model regulation that continues to be sort of worked up the chains there at the NAIC. So a lot of moving parts separate from what the SEC is doing to keep track of.
Okay.
So with that, I'll turn it over to Cliff and Michael. Do you have any comments?
Thanks, Ben. Appreciate it. We are going to go to our next few items. The first is GIPS 2020, and give you some background about GIPS, but more importantly, a focus on the recent initiatives. And Issa's going to walk us through that material.
Sure. So, I know we're down to about 15 minutes left here. We've got a few topics to get through, so I'll try to be as quick as possible with GIPS 2020. So just to provide some background on what GIPS is, maybe some of you are not completely familiar with it, but the Global Investment Performance Standards are voluntary standards developed by the CFA Institute, and the purpose of them is to basically ensure fair representation, full disclosure, and apples-to-apples comparisons of investment performance of investment managers. And the GIPS standards, as they exist today, have two principal components. The first are performance standards, and the second are advertising guidelines. The performance standards basically get to the process for calculating returns, and the second component, this advertising component, governs how you go about advertising those returns, disclosures that you need to include, and the types of the way in the manner in which you're supposed to advertise them. So, moving on to the next slide here, just with that background in mind, it's a reasonable question to ask. Should somebody really be compliant with GIPS? Should somebody come into compliance with GIPS? It's a voluntary thing. Is it really a necessary thing or an important thing for your firm to do? Well, it's an important thing to do if you're looking to compete in the institutional market. That's the first thing I'll say is that there's especially if you're looking to compete in the separately managed account institutional market. I think it's an expectation in that market, and I think it's something that you might want to consider also if you're a fund manager, whether you're managing a mutual fund or a private fund. It's something also to look into if you're doing that. The claim of compliance actually offers a significant marketing credibility advantage. So I think a lot of clients take comfort in knowing that the returns that are being presented to them by their investment manager are compliant with these standards. There's an element of confidence in performance returns, that they're reported to clients when they have the backing of these GIPS standards, and because they demonstrate a high ethical standard. If you do go forward with compliance with these standards, some things to keep in mind. If you claim compliance, if you advertise compliance with these standards, you have to be compliant. There are no exceptions. There's increased regulatory scrutiny if you do advertise compliance, with these standards, especially from the SEC. There's significant work involved to come into compliance with the standards, and there are also significant costs incurred to come into compliance. The SEC's position on GIPS is that, obviously there's no requirement in the Advisors Act to comply with the standards, but if you do claim the compliance, they will, and you don't actually, comply with the standards, the SEC has a history of bringing enforcement actions against investment advisors that make that type of misrepresentation. And an example of that, recent example, is the ZPR investment management case from 2015. Michael, you want to jump in?
Just something very, very quickly. GIPS got a lot more attention following the F-squared case and the series of cases following F-squared, because there was language in that enforcement action that really scared the industry, in that it really tended to potentially require third parties to come in and do some sort of objective analysis. And there was a lot of discussion at the time of whether that was going to cause the retail advisor market to rush to become GIPS compliant. Because one of the things, if you're GIPS compliant, is you have the ability under the framework to be verified by a third-party verification firm. And that was the SEC staff in conversation said that would suffice, that would be fine, but they didn't say anything else about what else would suffice. And so that was the only thing that was referenced. And so at the time, people were wondering whether there is anything else that would really suffice, and whether that, as a practical matter, would require folks to become GIPS compliant. That has kind of died a bit. There hasn't been statements like that appeared in the F-squared case and the cases that immediately followed, but it's still, that concept is still out there. So I just wanted to give folks that context.
Yep. Thanks, Michael. So moving on to the next slide here. Why are we talking about GIPS today? Well, GIPS is potentially undergoing a significant overhaul in the form of GIPS 2020. That's the name of the initiative, GIPS 2020. So in May of 2017, a consultation paper was released for public comment. And then subsequently, the CFA Institute issued an exposure draft of the 2020 edition of GIPS that came out earlier this year in August of 2018. The comment period is going to be closing later this month in December, And the idea is that the new standards, the new GIPS 2020 standards, would have an effective date of January 1st, 2020. And just overarching kind of purpose of why the CFA Institute is getting into this revision to the GIPS standards is the idea is they've seen a significant uptake of GIPS with SMA managers in the institutional space, but they have not seen the uptake that they've wanted to see in the mutual fund and private fund alternative investment manager space. So the idea behind these revisions to GIPS is to make them more friendly for these other types of managers who aren't really operating in this institutional SMA space. In the next set of slides here, I kind of go through the various ways in which GIPS 2020 would be different from the current standards, which are, I guess, the GIPS 2010 standards. And I'm not going to get into a detailed discussion here given the time constraints that we have, but just to kind of highlight the main areas in which the standards are becoming more friendly for alternative investment managers, for mutual fund managers, et cetera. The third point here, this idea of composites versus pooled funds, this is a big thing for private fund managers. There's a general rule within GIPS that every portfolio has to be included in a composite, even if it's basically a strategy of one, and that's been problematic for a number of private fund advisors, because they might maintain a whole suite of private funds, each with a different strategy, and that would require them to come up with a composite for every single one of their funds, which practically doesn't make a lot of sense. It makes a lot more sense for an investment manager who's managing a number of client portfolios, SMA portfolios along the same strategy. That makes a lot of sense to come up with a composite that kind of combines all of the performance across all client portfolios. But if you have a private fund that follows strategy A and another one that follows strategy B, why come up with a composite for each fund? And it's misleading to call it a composite when it's only one fund. So that's been a big reason for private fund managers not to uptake the GIPS standards, and that's a significant concession I think that the CFA Institute is making for that industry. The next thing that I wanted to highlight, moving on to the next slide, was this topic of money-weighted returns. This is a big deal for real estate fund managers. A big reason why real estate fund managers have not taken up GIPS is because the current standards require them to present their returns in an IRR and time-weighted return standard. A lot of real estate fund managers can only really produce it on an IRR basis, or only comfortable doing it on an IRR basis. And what this basically does, this revision in GIPS 2020, is it allows those real estate fund managers to present their performance on an IRR basis. And then, last thing here, moving on to the next slide, I think another big, a significant change here has to do with portability. In the current version of GIPS, if you purchase another asset management firm or merge with another asset management firm, and you want to show your historical performance prior to that merger, prior to that acquisition, there were certain portability issues associated. And if you wanted to show the combined firms, performance, that you actually had an obligation to show what was happening at the old firm. With the new standards, you have the option. If you merge with another firm or you acquire another firm, you're not necessarily required to show the old firm's performance anymore. You can just provide your performance on a prospective basis. It's optional now. So that's a big concession, I think, that's been made as part of the CFA standards. That'll make the standards a bit more palatable for the industry. So with that, those are the main, I think, points about GIPS 2020 that I wanted to cover, and just wanted to turn it over back to Cliff to close out here.
Yeah, well, in fact, we have one more topic, and then we'll give a couple of thoughts in terms of 2019, and we'll keep an eye on the clock. And Bria, maybe I could turn it to you to spend just like a minute or two on the enforcement development we wanted to highlight.
Sure, thanks, Cliff. So one informative enforcement action from the third quarter of this year involved the SEC charging violations of Reg SID and Reg SP. Those are outlined here. Kind of their summaries are here. Reg SID in particular requires advisors to develop and maintain written policies and procedures that detect, mitigate, and prevent identity theft, whereas Reg SP requires advisors to adopt written policies and procedures that address administrative, technical, and physical safeguards for the protection of customer records and information. On the next slide, we talk about the most recent enforcement action. In late September, the SEC announced an enforcement action involving Reg SID and Reg SP. The enforcement action marked the very first by the SEC charging a violation of Reg SID. It involved a phishing incident from 2016 through which client information, personally identifiable information, was compromised. The SEC determined that the advisor violated Reg SID for the following reasons. First, the advisor had not updated its written identity theft prevention program since 2009. In addition, employees were not trained to adequately respond to identity theft risks. And the SEC found that reasonable procedures weren't in place to prevent and respond to red flags. The SEC also noted that the advisor's policies pertaining to resetting its contractor representatives' passwords and identifying high-risk client and contractor accounts for extra protection were not reasonably designed. But the SEC did consider the advisor's remedial actions, which are listed here, when reaching a settlement with the advisor. The key takeaways from this enforcement action are that, first, advisors should not let their guards down. This was the SEC's first Reg SID enforcement action, but a lack of previous enforcement action does not necessarily mean that the SEC won't enforce these regulations in the future. Second, Reg SID and Reg SP will be enforced even if there's no harm to clients as a result of the breach. The SEC did acknowledge that there have been no known unauthorized transfers of funds or securities as a result of this attack, but the SEC still brought the enforcement action because the intruders accessed and modified client account information. Lastly, it's just not enough to have procedures in place. They do need to be applied and updated regularly. So they need to be functional, and employees must receive proper training to be able to respond appropriately to threats. In addition, the procedures must be responsive to external cybersecurity risks, and they must be tailored to a company's personal risk profile. So with that, I'll turn it over to Cliff, Michael, or Issa for any comments.
Yeah, thanks, Bria. And in fact, we're going to move to just 30 seconds, taking a look ahead in 2019, some of the things we anticipated. Again, just a minute or so on that. The SEC has indicated that they will be taking a look at the advertising rules under the Advisors Act. So that's a welcome development for the industry, and with a look to modernizing the rules, and more importantly, taking everything that's been said by way of guidance, no action letters and the like, and folding it into a rule to make it much more easy, make more sense to deal with.
Yeah, I mean, we have 30 years of no action letters that one has to really leaf through to understand what's allowed and what's not allowed, and also the rules were adopted in 1961, before the internet, before social media, before modern communication, before apps on the mobile phone. So, really,
the Dick Van Dyke Show.
It's like the Dick Van Dyke Show, yes.
That's fun. Yeah. So that's the marketing review. We have down, of course, the standard of care initiative. We do everything that the SEC has been signaling is that they're going to push ahead in 2019. And as we mentioned earlier, we expect to see something, or I should say the SEC has signaled September 2019. A couple of other things that we may see, the custody rule. In the last week or so, the SEC put forward a number of rules that they would be applying a retrospective rule review, and custody was one of them. We anticipate comments coming in. And along the lines that Michael was saying with the advertising rule, a lot lives outside the rule, in terms of guidance. The same thing with custody. We have FAQs, releases, no action letters, a very, very expansive definition of what constitutes custody. So again, we may see action there. And also, proxy advisors is getting a lot of attention, and it's something to keep an eye on. There's a real push to regulate proxy advisors, given the power that they exert, the influence that they have. So we may see something develop there. A lot of that is legislative now, but the SEC has had hearings, so more to come on that. And with that, I think we're ready to close out another year of Webcast. So thanks everyone who's been joining us. We like doing these, and we appreciate everyone coming, tuning into them. We'd like to thank you for joining us today, and we hope you'll join us as we begin 2019 Webcast. We're going to keep the same quarterly webcast format. As a reminder, if you'd like to receive CLE credit for this webcast, please download the CLE sign-in sheet and evaluation form from your viewing console and follow the instructions for submission. And also, if you have any questions or you'd like to request a copy of the slide deck, please feel free to reach out to any one of us. We'd be happy to speak with you or get you a copy of the deck. And with that, we'll sign out. Take care, everyone. Bye-bye.